Good morning, ladies and gentlemen.
Good morning.
You're almost done. That door is just a little bit away. But first, let me thank you for acting as a juror. We all know you'd rather be doing something else. This is the week before Thanksgiving. You have deadlines, you've got work, you've got family time. And we appreciate the fact that you're here. The judge said it at the beginning, and let me just express our thanks, because second only to serving in the military, this is the #1 thing you can do as an American citizen. Jury service makes us different from every other country on earth. This is the only place we have this. And the judge and us all fight to keep civil juries alive. They want to get rid of them. Budget cuts and everything else, they want to do away with this system. They want to use it only for criminal. And it's important that we keep it for civil. So we appreciate you being here. Now, that having been said, let's go to what we have in front of us. Because now it's your job, and believe me, you have the most difficult job in the courtroom today. Because you have to decide. You have to evaluate all the evidence that's been in front of you. You have to look at the exhibits. And you have to go back and discuss this. And decide the fate of one side or the other. That's your job. Judge's job is to call balls and strikes. Plaintiff attorney's job is to advocate for his client. My job is to advocate for mine. Your job is to weigh everything and make the determination. So now how do we do that when we're looking at this Rite Aid store and something that happened 3 years ago? Well, what you get in this case is you get a special verdict form. And let's go over it so that you see it. And we can go through the questions. And this is the exact form that you're going to get back in the courtroom, back in the jury room. And the first question, you have to go through it question by question. The first question is, did Rite Aid lease, occupy, or control the property? Well, the answer to that, ladies and gentlemen, is of course. I'm not disputing that she didn't have this alleged event occur in a CVS or a Walgreens. She claims it happened in a Rite Aid. I'm telling you, it's Rite Aid 5425, 3rd and Vermont. So the answer to that question's got to be a yes. That's where we differ at that point. Because when you go to question number 2, was Rite Aid negligent in the use or operation of the property? And the answer to that question, ladies and gentlemen, is no. Now, what evidence do you have about Rite Aid's use and operation of the property? Well, that goes to that box right there, being stacked on the shelf. That's what this question is about. Did Rite Aid improperly stock that box on a shelf? Or did they stock it on a shelf that was not in conformity with industry standards that every other retail pharmacy would stock? Well, who do you have on that point? You have Mr. Avatizian, who said that before Christmas, it was stocked 4 across at a height of 5 feet 6 inches. That was the tallest shelf in the store in December of 2007. That's how high the shelves went, this high. Eye level for every adult. Even Mr. Ballian agreed. Eye level is the appropriate height. You can put them on the bottom, you can put them on the middle, but the highest you can go is eye level. That's this height. You have Jeremiah Milne. And she testified, yes. For Christmas, they're on the toy aisle. 5 feet 6 inches, all the way across, 4 high, not too high, 4 across, and as deep as the 18.5 inch shelf would go. The reason why you don't want them up high during Christmas is because parents and children want to get them. You don't put them up high. You have the space because you're selling them. Even Dr. Solomon said that. And the shelves are tilted back slightly. 2 degrees is what he said. Jeremiah Miller said, I stopped. I moved the shelves are all tilted. The reason why they're tilted is so if it falls, it goes backwards. Now, Mr. Bellion says, I don't care where you stock it. I mean, really, when you synthesize his testimony down, Mr. Bellion says that box in any state is unstable. It will fall if you put it on the bottom, the middle, or the top. And, by the way, I measured it, and it was up at 6 feet 7 inches. Well, you know, if you come into my store 3 years later and you make a measurement, and we've done a major remodel, the shelf's not going to be the same. And you should simply concede that point, but he doesn't. And all you had to do was look at the photograph, and the photograph told you that shelf is 5 feet 6 inches tall because that's the end cap. Now, the only evidence you have in this case that it's not improperly stocked, that it wasn't up there the right way, is from the plaintiff herself. Now, and the only evidence she provided you, ladies and gentlemen, is this. But really, when you think about it, if you remember back to the first day when Ms. Lopez was being questioned, late in the day, Tuesday, this was up on the board, and they asked her, her own attorney asked her, is this how it was on the day of the accident? And she blurted out, no, it had been changed. Mr. Gomez got really flustered about that. Went on for a couple more questions, claimed there was a problem with translation. We took a break for the night. Well, we know that wasn't the way it was on the date of the accident, ladies and gentlemen, because the end cap is wrong. The end cap, the red on the right, the red on the left over here, that is an end cap. This is the end of the shelf. This is to the left. The other thing is, that's a clearance section. She also testified that a week after this accident, she sent her husband and her son back, husband and daughter, back into the store to take the picture. She stayed at home. They went into the store, they looked for an aircraft carrier, they took the picture. She couldn't have showed them where it was in the store because she wasn't there. So the only evidence they have of these items being improperly stocked is, as Dr. Solomon said, it's irrelevant. It's at the wrong place. It's at the wrong location. It's at the wrong stack. The evidence in this case, ladies and gentlemen, is that those things are in a different location. Now, why do we also know that it's in a different location? Because the plaintiff testified that when the accident occurred, she was up here in the holiday and ornaments section, closer to the check stands, not over here where the picture shows the end cap. And she claims that she never saw anything hit her. That's key. I never saw it. I heard something. I felt something. But I never saw it. What I did see is when I turned to the right, I see a box of dishes on the ground, and I know that couldn't have fallen off the shelf and hit me because I'd be dead. But I turn my wheelchair, and I don't just turn to look. I literally rotate my wheelchair 90 degrees, and I look over to the side, and the box is still at least 2 feet away from me. 2 feet away. Now she says that I looked up and I saw a pyramid of boxes. But ladies and gentlemen, that doesn't make sense because she also testified that she took her wheelchair and she drove it around to the toy aisle to look for what hit her. Well, if it's up above you, why do you have to drive to the next aisle? There's no evidence that this box was improperly stocked that night. Now, ladies and gentlemen, that box is an exemplar of the box that was in the store. That's as close a replication as we could get to it. Ordered it from the same manufacturer, they just changed the outside. Now, let me also assure you that it's a little different in character because I've had that box for about 1.5 years. Now, it's been in my office. It's been in the back of my car. It's gone through the metal detector a couple of times. And it's been through site inspections. And when you pick it up, and you will get to pick it up, we'll put it back there with you. You'll see it's got some little dents on it, and it may have some caving in. But it's styrofoam inside. Now, that box is different from the box that was on sale on December 23, 2007, because the boxes that we had on sale are pristine. They come from the manufacturer in a crate, in a box. We then take the boxes and we put them on the shelf. And why do we know they're not a little bit dinged up like that box? Because nobody wants to purchase a dinged up box for their child or their grandchild. Everybody passes over the dinged up boxes and you get the great boxes. That's what gets purchased that night. Now, ladies and gentlemen, this ledge right here on the edge, which is the same ledge in front of you, is smaller than the box. I put that box up there every day. Every time I start a direct or cross-examination, I put the box up. It's now 11:20. That box has never fallen. If it's as dangerous and falls down as much as Mr. Bailey said, that thing would be falling all over the place. It hasn't fallen once. And that's even smaller than the box. So there's no evidence in this case that Rite Aid negligently stocked that box on December 23, 2007. And Exhibit 3, the photograph, is completely irrelevant because it's taken a week later. It shouldn't even be in evidence, ladies and gentlemen. But if you get, and when you answer question number 2 should be answered no. But if you do answer question number 2 yes, then you have to go to question number 3. Was the negligence of Rite Aid in the use or operation of its property a substantial factor in causing harm or damage to Ms. Lopez? And again, I think the answer to that question is no. The reason why it's no is that basic physics tell us that if Ms. Lopez was facing the shelf, she wouldn't have her toes up against it. She'd be back a little bit. And she's sitting in a wheelchair. And we know that if the box is 16.5 inches tall, it falls directly down. Even if we go with the premise that Mr. Gomez suggested, and I do not agree with this one bit, but he did get Dr. Solomon to testify, well, if you put a box on top of a box, what's the maximum distance? It's not 32, it's not 33 inches. You don't double it. Dr. Solomon said you take half the mass of the second box. Half the mass. Puts you at 20. 20 inches still doesn't get to 30. You're still 10 inches away from the head. The other problem with the two-box theory is where'd the second box go? We saw one box some ways, some distance away from the planet. If there's a box being pushed from behind, where are the other boxes? Isn't it more reasonable that some customer picked up the box, was walking down the holiday ornaments aisle, and just like the dishes, put it down because they didn't want to go back to the holiday ornament aisle and put the box on the shelf? The only evidence you have in this case is that Ms. Lopez saw a box of dishes and a toy aircraft carrier. That's it. Even if we go to the other version, where she's looking the other way, a box still would not hit her. And ladies and gentlemen, she testified that she had her glasses on, and a basket in her lap. None of those things got knocked off by this box that hit her. The evidence in this case is that it didn't strike her. Dr. Tauber said that. And how do we know that? Paramedics called to the scene. Paramedics found she never complained. No neck pain, no back pain. She goes to the ER room. No neck pain, no back pain. They both said if she had complained of neck pain or back pain, even the slightest neck pain or back pain, we'd have C-collared her in a minute, strapped her to her backboard, and paramedicked her to the hospital. They said they taxied her in the EMT unit. She hires her attorneys 2 days later, December 26th. They send her to a doctor, not the regular doctor she treats with for her CMT condition, their own doctor. Their own doctor, Dr. Schemmer, on the 26th of December finds, no, she doesn't complain to him of neck pain or back pain. They fire him and go get somebody else. And somebody else. And somebody else until they ended with Dr. Kdunbar. Now, you do have other jury instructions. And the jury instructions in this case, one of the most important ones is statements made by a patient to a physician. Dr. Kdunbar has testified that Ms. Lopez made statements to him about her medical condition. Well, we know the statement she told him. When he asked her the question, did you have any prior medical conditions? She said no. No. Well, there's another jury instruction you need to look at, and that is instruction 2.22. A witness willfully false. A witness who is willfully false in one material part of her testimony is to be distrusted in all others. Why is that important? Because what Dr. Tauber told you. A doctor's opinion is only as good as the basis of the information he's given. Ms. Lopez told Dr. Kdunbar, she had no prior complaints. None. She told me, in the answers to interrogatories, did you have any prior complaints, where she verified it under penalty of perjury as if she were sitting on the witness stand? Did you have any prior complaints? None. When you look at what she said about the motor vehicle accident in 2004, oh, my husband got injured. He got the neck injury. And yet when I had to show her the interrogatory answers where the first complaint from that 2004 motor vehicle accident was for her neck, they backed off that. I love the being run over by a car incident because I can't show it to you because the plaintiff's attorney objected to it and wouldn't let me show it to you. But I sure read it to the plaintiff here. 2002, from the Clinica Moreno. Complains of recent accident while on automatic handicap car. Run over by car was seen at ER. I read it. That's a complaint from her. Not that she almost got hit, not that she nearly got hit. Run over by car was seen at ER. I'm not hiding anything, ladies and gentlemen. That's her own words to a doctor for the purposes of medical treatment. That can be trusted. How about all the falls? Fall in 2007 at her home. Again, if you don't give the information to the doctors for them to make an opinion regarding your testimony or regarding your treatment, they can't give you the right conclusion. Dr. Kdunbar had no other conclusion, no other basis for his conclusion other than that box because the plaintiff never told him about her falls, about her accidents, or anything else. I have Dr. Kdunbar's trial testimony here, And Dr. Kasimian, during his trial testimony, even agreed with Dr. Cruz that yes, the only problem is Dr. Kasimian only looked at the 2009 MRI. He didn't compare it with the 2008 MRI, which did not show any cord compaction at C2, C3. But he saw exactly what Dr. Cruz saw in the 2009. She had an event, which didn't show up on the 2008 MRI, which means she had another accident after March of 08. And that what you saw on the 09 MRI was a significant disc protrusion where the disc, can't even read it. The disc goes down anteriorly behind the vertebrae. Just like Dr. Cruz said, it goes over and it goes down. Something that hadn't been there before, which means another accident had to take place. And it's that caused the cord compaction. Plaintiff took issue with Dr. Cruz saying, well, the degeneration you saw in 2008, you said that could be as long as 10 years and as early as 6 months. 6 months from, or 3 months from April of 2008 is December 2008. 6 months from March 2008 is September of 2007. You got to take the 6 months because that's what the doctor said. Doctor didn't say 3 months. 3 months would put you at December 2007. He said 6. That's September. 3 months before our accident. She had the degenerative condition. Ladies and gentlemen of the jury, when you get back to the jury room, I think you can discount the plaintiff's testimony in this case. She never saw what hit her. She never saw anything other than dishes on the floor and an aircraft carrier box. She didn't tell any of her doctors about the priors. She didn't tell us about the priors until we confronted her with the evidence that we already had. The medical expenses, even Dr. Cruz said $5,400 for an MRI scan. Outrageous. $1,300 is what we charge. Of her $24,000 in past medical expenses, $11,000 of that total is diagnostic testing that the doctors have said is exorbitant and way over the top. This is a case, ladies and gentlemen, where Rite Aid stocked this box appropriately, stocked correctly. There was no negligence on behalf of Rite Aid, and as a result, I request that you provide us with a defense verdict in this case. Now, here's the hardest part. I have to sit down. Plaintiff gets another 15 minutes. It's his verdict. I don't like the system, but I gotta live in the system. Which means he can say anything he wants, and I can't say a thing. I have to sit there and be quiet. As my wife will tell you, that's pretty difficult for me. I don't like doing it, but I have to. So, if something new comes up that wasn't brought up on his original opening that I could respond to, you need to ask yourselves why it wasn't brought up. Part about the car was brought up. Boom. What I have? Medical record that showed completely false. So, if something new comes up, ladies and gentlemen, you need to ask yourself a question. Why is it coming up now? Why didn't you bring it before? And why didn't you let him have a chance to go after you on it? You need to remember that. I can guarantee you some new stuff's going to come up. So, with that, ladies and gentlemen, I want to thank you for your time. I do want you to go through this special verdict. I think the answer to question number 2 is no. Once you get that done, that's over. Thank you very much for your time.
Thank you. This one.